All right, we got everybody up here. Anyone who's going to testify in this matter, raise your right hand. Let's place you under oath. Ms. Fain, if you'll come on up, let's step a little closer to the microphone there and make sure that microphone is on. It is.
Since May 27th of 25. He's 13. I do. We have. He's my son. He's my son. Very much so.
And Jacob, as excited as okay, thank you. Your name?
My name is Keith Fain.
And Mr. Fain, all are both ready.
All right, Mr. and Ms. Fain, when people get married, there's that statement about for better or for worse and all that kind of stuff. Well, that also applies to children. And when you adopt a child, then he's yours for better or for worse. And he's a teenager already. He's a good-looking young man. But you understand that he is a teenager and things could only get more complex from here on out based on my experience. But both understand that we're changing the nature of this relationship between you and Jacob. And no longer will you just be foster parents. You're actually going to be his parents the same as if he was born to you. He'll inherit from you and you will inherit from him. God forbid something happened before he turns 18 between the two of you. You would be subject to the same rules regarding custody, visitation, support as a couple who had a birth child. Everybody understand everything? Jacob, you understand what we're doing? And you understand that this means that they might, you're going to have to talk to them about buying you a car when you turn 16 or 17. If you don't come back to court and ask me to do it, you're going to have to talk to them. You understand that? All right. Well, I think you've had him long enough to know what's going on, and I'm happy to see that you have formed the bond that you would like to make this a permanent union, so we'll grant your adoption. And I don't want to cast any aspersions on how things are going to go from here on out. You're 13, is that right, Jacob? And you know what today is? Friday the 13th. If I was a suspicious or a superstitious person, I might be worried about that. So. Ms. Smith, I have signed the order and granted your adoption. You may. Anybody wants to be in the picture want to come up here? We can do it right there.
Going up.
Let's just do this. Come on around here. Oh, we should have put her in the chair.
Well, there's two of them, so.
Yeah.
They might be fighting over that. All right, congratulations.
Thank you, sir.
Thank you.
Here, y'all have a couple. Yeah. All right, I need to step off for just a minute, and we'll take a very short recess. Call the next case.
29 CV 231 in the matter of Scarlett Annabelle Bailey.
Judge, we're before the court on an order, on a motion for default and termination of parental rights with regard to Mr. Zachary Summers. Mr. Summers was served with this and has not responded within the time required by law. We're asking, as a result of that, that his rights be terminated, and if my clients can be sworn, I'll put the facts on the record.
Everybody raise your right hand. Let's place you under oath.
Would please state your name for the record. And you came into my office and and Mr. Summers has not had contact with this minor child for more than 4 months immediately preceding, has not supported this minor child in the 4 months. He has also failed to establish his parental rights despite knowing that he wasn't acted upon. Are you asking that this court terminate his parental rights based on facts? And do you believe it's in the best interest of this minor child to terminate his parental rights? You heard all the questions that I asked of the boss. And do you agree with all the statements that we've just made? Are you asking that once the termination takes place that you be allowed to adopt the child? Scarlett, you heard everything I said.
They think you might be carrying a pistol in your pockets. The reason it is a standard security measure that we always tell anybody who's standing up there, they always tell them to take their hands out of the pocket, so don't take it personally. So they might have thought you snuck a cell phone in or something like that. So
They're actually a lot nicer than they look too. You heard everything I said. Judge, I'd ask for the termination to be effective today and then me be allowed to put on the adoption proof.
Right, based on the service of the defendant and the failure to file an answer, the court finds that the default judgment should be granted. The court further finds that the best interest of the minor child is that the parental rights of the defendant be terminated. I find so by clear and convincing evidence. All right, you may proceed.
Now, and you have are you asking this court today are you financially able and capable of providing? Both of you understand that if something were to happen, asking that that be done. Are you wanting to be adopted today? Get him as a father figure? Are you wanting to change your last name? Good. And you look at him as a father? Judge, that's our proof.
All right, based on the clear and convincing evidence, the court finds that it is in the best interest of the minor child that this adoption take place. Mr. and Mrs. Cederoth, you understand the significance of this, specifically Mr. Cederoth. You understand that we're changing the nature. Right now, you're a stepfather. We will, and it's a compliment to you, in my opinion, that you have formed such a bond with Scarlett that both you want to adopt her and she wants you to adopt her and become her father in fact. And that's what we're doing today. You will no longer be a stepfather. You're going to be her father, the same as if she was your biological child, and that'll happen in every way, shape, form, and fashion. You understand that? And Mrs. Cederoth, you understand that you are agreeing to and committing this relationship to the test of him being the father of this child. So he's going to have an equal say about who she gets to date and what she gets to do and whether she gets her homework done. Stepfathers sometimes have to stay in the background, but now he's going to be her father, the same as you. You understand all of that? All right. Scarlett, you okay with this? You understand what's happening and that this is he's going to be your dad. We don't always get to choose our fathers, but sometimes in a situation like yours, you get a say in that, and that's a pretty special thing for you. And we're changing your name, and I give every young lady who stands before me that I'm changing their name the opportunity. I can change your name to anything you want it to be. If you want it to be Travis Swift, or if you want it to be Taylor Swift, rather, I messed up there a couple, Travis Kelsey, and anyway, you can change it to anything you want to. You're satisfied just changing the last name? You don't want to be anything else? All right. And I will grant the adoption, and I think it's in the child's best interest, so we'll grant that adoption. All right. Now come on up here.
We'll take one with and one without.
Want to have a seat? Please, chairs. You're going to push it up where you can. Without me in it too? Taylor, you want to change it? Individual, yeah.
I'll be right back.
Sign this already.
Matter Ronnie, 1,000.
Good morning.
Good morning, Your Honor.
I have a motion to withdraw and a final hearing on a termination of parental rights.
Yes, Your Honor. My client, I have not heard from my client in quite some time. He was in DC 4 in Davidson County. When I look up on the Tennessee Offender Registry to find out how he's doing, he is noted as absconded. So
The respondent has absconded and failed to appear. There has been no contact, no support, and no effort to establish parental responsibility. Based on clear and convincing evidence, the court finds termination of parental rights appropriate and in the best interest of the child.
thank you, Your Honor.
You're going to go forward today? All right, let's bring everybody up that's going to testify. Everyone's going to testify. Raise your right hand. Let's place you under oath.
Did you say your name?
Samantha Prim.
And Ms. Prim, you are the mother of Bonnie Lane Dawson. Okay. And Mr. Caleb Dawson is,
Yes.
how long has it been since Mr. Dawson?
The last time they spoke, I believe, was early May 2023.
And Mr. Dawson has made no see his child.
No.
When is the last time you actually saw?
The last time that they physically saw each other was Christmas of 2022. No.
Has he tried to communicate with you at all?
No.
Has he made any attempt in the 4 months preceding the filing of this petition to exercise any type of visitation?
Yes.
How,
Yes.
are you asking the court to terminate?
I am.
And you currently read,
Yes.
is this your husband?
This is my husband.
And what is his name?
Landon Prim.
And how long have you been married?
It'll be 2 years in May.
We've also, in addition to termination of filed for
Yes.
and you are obviously in agreement and you would like your husband.
Yes.
And we're going to move forward on the adoption on a later date.
Yes.
You are in agreement with that? Yes. Yes, Mr. Prim, been in your spouse.
4 years we've been together.
Landon Broom.
And Mr. Prim, you filed and joined in a petition. And then also for step-parent adoption, correct?
Correct.
And how long have you been in the minor child life?
A little over 4 years.
And during that time?
Ms. Coffenberry, you're the guardian ad litem.
Received anything.
All right, based on the evidence before me, I find by clear and convincing evidence that the motion, that the termination of parental rights of the respondent should be granted. And I therefore grant the motion to terminate, or the petition to terminate parental rights of the respondent. And you want to set it for a hearing on the adoption at a later date? You have a date in mind, or how long do you want to put it
Given the
off?
circumstances, we'd like to set it out 30 days.
What about March 26th? I'm sorry, March 23rd. Didn't I say Boyd versus Boyd yesterday? March 23rd?
I'm available.
All right, March 23rd it is. Thank you.
Credit Ray of Jerry Freeman Owen.
Morning, Your Honor.
Good morning. You'll raise your right hand and be placed under oath. Let's bring up, does
Dennis
Mr.
Harlow. You are the sister of Jerry Owen. He lived in Madison County, Tennessee. That was back in, 2011. And your parents have since passed away. You're asking the court to transfer the conservatorship because Jerry wise moved to Dixon. You like living in Dixon County, correct? So we're asking the court to transfer provisionally the conservatorship from Madison County to Dixon County pending their order of transfer. They are his representative patient. Asking that the court also grant standby conservatorship to your cousin, Vicky Harlow.
Right,
And you're happy for this to go forward?
right.
Thank you.
All right, the court will approve this request. Mr. Owen, you're lucky to have people who are willing to step in and help take care of you. Sometimes I wonder if I need a conservatorship myself, so. All right, thank you.
Thank you.
And 25 CV 318, Diane Rayburn versus John Rayburn.
All right, good morning. This is a motion for default in this divorce action, is that correct?
Yes, Your Honor. I represent Ms. Rayburn. We've served Mr. Rayburn with service in this matter, and he has, we served him with notice of today's hearing and the original hearing that was scheduled during the ice storm. I believe he's contacted the office to say that he's unable to be here this morning due to transportation issues, so he obviously is aware of this hearing, and we are ready to proceed on this case.
All right, all those who are going to testify, raise your right hand and let's place you under oath.
Ms. Rayburn, we'll start with you. Please state your name for the court.
Stephanie Diane.
And you are married to Mr. John Christopher Rayburn, is that correct?
Yes, sir.
You all have been separated now for some time. How long have you been separated? Okay. And you supplied to my office certain information with respect to your marriage, including anniversaries and those things. Was all that information true and correct? And is there any, are there any items of property or any marital debts that need to be divided between the two of you? Have any real property together as husband and wife? You asking the court to award you a divorce today and allow you to retain your personal property and him to keep his personal property? You pay your debts, he pays his debts. Tell the court, if you would briefly, why it is that you're asking for a divorce from Mr. Rayburn.
I am asking for a divorce from Mr. Rayburn because we have irreconcilable differences. We cannot get along.
And just for the record, I know she used a legal term, but.
She used the magic words irreconcilable differences, but I can't grant a divorce on a default basis on irreconcilable differences. So you need to tell me what a bad husband he was.
Hey, well, he lied a lot, he cheated a lot, he fist fought a lot out. He took me through the ringer.
Sounds like a bad husband to me.
Yes, Your Honor. And you're also asking the court to grant you a name change as part of this case, is that right?
Yes, sir.
And you're wanting to go back to Stephanie Diane Martin, which is a previous maiden name, is that correct?
That's correct.
Okay. Please state your name for the court. Sanders, you heard the things that Ms. Rayburn testified to here today, correct? You know that those things are true, and you know her to be a truthful person. Please state your name. Do you know Ms. Rayburn? Proof, Your Honor.
All right, I will grant the divorce on default basis on the grounds of inappropriate marital conduct. She is awarded all personal property in her possession, and he is awarded all property in his possession. There are no joint debts. Her maiden name is restored.
Thank you, Your Honor.
Thank you. Good morning.
I have two matters before the court on this. The first is an exception to the claim of J.P. Morgan Chase Bank.
Anyone here to prosecute the claim of J.P. Morgan Chase Bank? No one here to prosecute the claim. Your exception is granted.
The second, judges, I have filed a motion, and Mr. Odle and Ms. Roberts are involved in this matter as well. We submitted an agreed order that authorized me to sell the decedent's real property here, as the only beneficiaries are minor children. Ms. Roberts has filed guardianships for each of the children. Mr. Odle is the guardian ad litem, both in the guardianships as well as in the estate. All of that to say, we have a contract before the court that needs to be approved for the real estate. This property was listed for sale. It contracted very quickly over asking price. I believe that it is a very good offer on this property. And we have requested, given all of the different dynamics with the guardianship ongoing, Ms. Roberts has filed a claim on the estate, which I'm not sure whether she's going to pursue, for child support, but given all of the pending claims, we've requested that this money just to be posited with the clerk and master, pending further order.
All right. So is everyone in agreement for the sales price?
Yes, Your Honor, the only thing that would be left to be done is pay the expenses. If it closes before we get that done, it needs to be.
It was $530,000 is the sales price.
Yes, Your Honor.
You have an order?
I do.
I have signed your order. Thank
Thank
you.
you, Judge.
Good morning, Your Honor.
Good morning.
Judge, this was our petition to open the estate of Janice Mumford, and also a petition for letters of administration. Judge, before the court is the only living heir at law. That would be Mr. Craig Neely. Judge, we're asking the court, one, to approve the appointment of Mr. Neely as the executor of said estate, and also the petition in and of itself to open the estate does have the language that states, while we could not find the original will, Mr. Neely was able to provide a copy of that last will and testament.
He's the only heir, right?
He's the only heir, Judge.
Well, then you want to go ahead and open it as an intestate estate, or you want to open it as a testate estate?
Judge, it may even be easier to open it intestate. I mean, he's the only living heir at law, so there's not going to be a question as to whether or not it needs to move
Well,
forward.
let me alert you, I know that Miss I've known Miss Mumford, knew her for a long, long time. Of course, she was a bonding agent, and she had a bonding company, A&A Bonding. There are still some open bonds that will have to be dealt with out of this estate, I assume.
And he is well aware of this, Judge. We've been tracking him, and I did the
I
bonding. work
assumed
for-
that he knew that, but I felt like I needed to make sure everybody
Absolutely.
was on the same page.
Absolutely.
Then I don't see any reason why we can't go ahead and open it as a testate estate, intestate estate. If you decide you want to find the original will or you want to file a copy, we can change it to a testate estate, however you want to do it. But
And
right
we
now,
did
let's
file
go.
a copy of said will, just for clarification.
We have to set up a lost will in order to do that.
Correct.
So
So-
it may be simpler to do an intestate.
I think we would
estate.
just proceed with the
So he
intestate.
he will be designated as the administrator of the estate.
Correct.
And I see no reason to require a bond.
I don't either, Judge.
All right. Inventory bond are both waived, and I'll appoint him as the administrator.
Thank you, Your Honor.
Right. Mr. Stelzy has not, so we'll enter an order that will be in the file to show that he's not in compliance with the requirements of the parenting plan, and that will be considered by the court in any future litigation.
Thank you, Your Honor. There'll be a petition for contempt filed on that. 2025 CV 166, median line versus
This is the parenting class citation for Mr. Michael Lyon. We find that he has not completed the parenting classes required under the parenting plan that was adopted. So an order will be entered showing he is not in compliance with the court's orders, and it will be considered as well in the future. Mr. Odell and Mr. Atchison.
Honor, that is on for temporary motions today. We have, in fact, I think, reached an agreement as to all matters that will conclude the divorce. Mr. Stamper is out of town.
Mr. Lyon, the court ordered you to complete parenting classes. You have failed to comply. This is not optional. An order will be entered showing your non-compliance, and it will be considered in any future proceedings. Court orders are meant to be followed, not ignored.
Motions are passed to March the 6th. That'll be in front of a different judge, correct?
I don't think it'll go anywhere,
Oh,
Judge. I just want a
that's
holding
fine.
place for it. Thank you, Judge.
Thank you.
Your Honor, we just need a new date on that one and the one following it. I think you've heard temporary matters in this case, but it was one long ago.
This will be a final hearing.
It is a final hearing on establishing a parenting plan. It was a paternity matter. We already established paternity. And so it's just to get a final parenting schedule.
So how long realistically do we think the two of you will take to try this case?
Well, it's Ms. Duke and I, so there's just no,
Half a day, maybe. I mean, I don't even remember the other.
I have the 23rd, but I'd set a Boyd versus Boyd case, and that one was when I
23 of
appointed Ms. Smith as a guardian ad litem, and I think it would take maybe a
was that the 23rd of this month, Your Honor?
23rd of March, I'm
Oh,
sorry.
March, okay, that's,
Well, I mean, I have,
well, the 23rd of February, Ms. Duke and I are in Humphreys County on a contested matter. So that was why I was making sure you were talking about the 23rd. I have mediation scheduled that day.
what about
With
the
with Mr. Potter.
what about the 24th?
The 24th, Judge, I have a
March.
final hearing, and that's a Houston, a Turnbow Houston Chancery day. I could try to reschedule my mediation with Mr. Potter.
March the 12th.
12th, I'm available on March the 12th.
We have a final hearing.
Okay, so,
What's happened is that we got on the phone with the clerk's office in Ashland City and went over the criminal docket, and the dates that I've been ticking off are the ones that there are no criminal trials, so those dates were opening up. I mean, I can give you the 23rd in the afternoon if you think you can do it in a half a day.
Judge, let me just do this. Let me contact Mr. Potter. Can you pencil us in on the 23rd? I have a mediation with Mr. Potter, and I think I might be able to move that.
I'll have the clerk pencil you in on the 23rd, and if that doesn't work, you can let us know, and we'll see. You may have to go in front of it, and you said I'd heard parts of this one.
You heard the first, there was nothing unusual about it. I mean, we could, other than, there was no smoking gun that you're gonna look at him and go, oh my gosh, I remember you.
Yeah, and I think that the order
So,
I'm good with the March 23rd.
yeah, I'll contact my office and make sure that there's no pressing matters to make sure that I don't need to have, if we haven't got that set right before final hearing. I don't think we have.
All right,
Next case.
The Jordan
Ours
matter.
also.
And I'm new to
Jordan
this.
versus Jordan.
Yes, Your Honor, I'm new to this case. Mr. Spratt had this before.
This is when I've heard some of them too,
Oh,
right?
yeah, you
You've
have.
heard quite a bit on this one.
And then Mr. Jordan, and again, I'm representing Mr. Jordan now, and Mr. Jordan has a huge, huge, huge hole to dig himself out of. He is currently he's completed a program. He is currently in sober living. He has additional charges in Kentucky that he went yesterday. We've working with that. Those charges are going to be pled in next month on misdemeanor charges. They were pretty serious, but he is completing his program. And so I don't know the issues really from the divorce and the property division is minimal. I think in that standpoint, it's centering around custody. And
April the
certainly.
2nd.
I'm available the 2nd.
That's a Judge Lockhart Mash Humphreys, but she has a number of days, so I can do it on that day.
All right, so April the 2nd will now be a Dixon Chancery, and what is the style of this case? It's Jordan versus Jordan.
Sarah Jordan
Sarah
versus
Jordan.
Josh Jordan. Yes.
Yes, it really boils down to just visitation and custody.
And really custody's not gonna be an issue, it's gonna be visitation. And again, it's gonna be supervised, and it's just who's gonna supervise it.
Mr. Jordan, your situation is already narrow. If you complete your program and remain sober, this court will consider that. If you fail to do so, the outcome will be even more limited. The responsibility is entirely yours now. The court will act accordingly.
There were some subsequent to the arrest things that were found in the home, and I just need to talk about
Right, so as I said, it's gonna be a very narrow window of what you're going to have to resolve. And that is if Mr. Jordan completes his program and stays sober. If he doesn't, it'll be even shorter.
Gotcha. All right.
all pending matters. There are a couple
Could you
that
say that again, just to make sure I heard you correctly?
it's unusual. I know when you saw this docket, you probably had a panic attack.
Well, I contemplated suddenly getting sick when I saw the number of motions that were pending, so.
Yes, and I apologize, my client was here earlier and has been part of the negotiations, and I
As long as
don't
both
see-
sides are in agreement with the motions, that you want to make an announcement of what the agreement is, or you're just going to submit a written order?
We're glad to do that.
Doesn't matter to me.
You want to just maybe walk through, we are striking two, I just want to make sure that the court is aware. The motion to expand parenting time and the resumption of joint sessions with the father and the minor children with Angie Johnson. I am striking that. That is my motion. The motion for return of personal property taken by wife from the marital residence, I'm striking that motion as well. And the remaining motions, we have resolved through our agreed orders, and so I'll let Ms. Castronova make an announcement with respect to all of the agreements.
So and I'll just run through the titles of
All
which
right.
ones they're resolving. So for the motion to compel husband to renew vehicle registrations and for related relief, we have an agreed order on vehicle registration renewal. For the motion to compel return of business equipment, we have an agreed order to return business equipment. For the motion to appraise real properties, we have an agreed order. For the motion for Pendente Light support, we have an agreed order for Pendente Light child support. For the motion to expand husband's parenting time and motion for phone calls, we have an agreed order for temporary parenting time. For the motion to quash the pena ducis tecum and/or for protective order, we have an agreed protective order. For the motion to request a second set of interrogatories and request for production of documents filed by husband and the motion to compel filed by wife, we have an agreed order on discovery. For the motion to preserve proceeds from the sale of real property pending final hearing, we have an agreed order. And that should do it.
All right?
Settle this. We have mediation date April 13th.
All right.
Working hard towards that.
Well, I'm very happy that you were able to resolve these things, not only for saving the time that we would be spending on all these motions in court, but also for the benefit of your clients. So congratulations. If you'll submit your order, I'll sign off on it.
Yes, sir.
Thank you.
Thank you.
I can pass these.
Thank you, Judge.
It's Friday.
You want to call the next case? I have about 4 more of these to sign.
That the court was closed down. And again, during that time, Mr. Oliva had not been served. Yesterday, I received from the clerk's office notice back that he had been served, but the paperwork that he would have been served with would have had the January date, not today's date where we were moved to. And again, I had my client come on and go just in the event. Her husband is an attorney licensed out of New York. He has recently moved to Tennessee and is working for an accounting firm. So we didn't know whether he reached out to find out whether the hearing was taped, so we set it on here, but I do want to draw your Honor's attention to the return of service. And it shows that he was served on the 4th of February by an individual by the name of Thomas Pillow. I was not able to reach out to Mr. Pillow. But again, it says served Nicholas Alejandro Oliva, left copy per request at address listed. So again, it's in one word, it says he served him, and the other one, it says he left it at the address. So again, I would like at the point in time, while we're here before the court, to determine whether court deems that that's appropriate service, and then us set a new date, and then I will forward notice of the new date hearing to him.
All right.
Or if Your Honor deems that that may be questionable, or if I could have the opportunity to get an affidavit from the officer to
Let's make sure of the service and then
Because
go
I
ahead.
don't know who told him to leave. It just said per request, but I don't know who requested
Why
it.
don't you go ahead and set another date, and that way give you the time for determining whether or not the service was effective. And
So nobody's heard this matter, so, I mean, it can be,
you be any judge, what's the next available date you got?
March 31st, yes, I have that Claiborne versus Davidson on that day, that's fine. And at that point, I'll contact the officer and get an affidavit to make sure that the request to leave it was personal of the defendant.
Okay.
Thank you, Your Honor, and I'll do a notice and get
All
that
right.
filed with the court.
March 31st it is.
Thank you, Your Honor.
And that one has been moved.
Holly was not available today. And we reset that, I think, to an April date. But I brought an order over today. I brought an agreed order from Mr. Holly supposedly sent the agreed order, and I've got notice of it. I brought an agreed order over on the Warren matter. Mr. Bates IV could not be here today, and so we moved that one. We have set that in front of Judge Lockhart Mash on the 6th. And then Mr. Sanders and I have the Holt matter, and if Your Honor could pass that to give us an opportunity. With the Holt matter?
The Holt matter is not on my docket, but apparently.
We brought an agreed order over setting it.
That's fine.
Yeah, so it's the only one left, if we could,
So the Holt matter is the only case we have left.
yes, Your Honor, and if you'll give us an opportunity to talk, then we
Well, that'll
can.
give me an opportunity to review the files, so.
Thank you, Your Honor.
We'll take a recess, and if you'll let me know when you're ready to proceed. We'll stand.